Welcome to Ground Rules, employment law over your coffee break. My name's Pam Howland, and I'm here with Jennifer Walrath and Doug Plass. And today we're talking about EEOC trends. This is not the first podcast we've done on EEOC trends. And in fact, it's our plan to occasionally circle back, keep you updated on what the EEOC is doing behind the scenes. So we're going to dive in today and talk about some of the very interesting issues that are coming across our emails and otherwise being sent out by the EEOC regarding their priorities. And some of these issues relate to those executive orders that we saw issued by the administration in the first couple of months of the new administration. And these really do touch on some big employment law issues. So I think when those executive orders first came out, a lot of people were going, how is this going to impact employment law? What is the EEOC? And just a reminder there, that's the Equal Employment Opportunity Commission, which is the enforcement agency charged with enforcing our big federal anti-discrimination laws. I think a lot of people were thinking, what is the EEOC going to do in response to these executive orders? We don't entirely know the answer to that yet. Some of these things are going to take a while to play out, but we are seeing some pronouncements and communications from the EEOC that give us a hint as to where the EEOC is headed. So we're going to talk about some big issues today. We're going to talk about some communications and guidance from the EEOC on DEI. So some diversity, equity, inclusion guidance coming out. Jen's going to talk about some LGBTQ communications and guidance. And then I'm going to wrap things up by talking about some other recent cases that we've seen, including cases touching on the Pregnant Workers Fairness Act. And we'll close things up based on some of the other cases crossing through our emails that we want you to know about. So with that, I'm going to turn it over to Doug, and Doug is going to talk about EEOC's recent communications on DEI.
Thanks, Pam. So if everyone will remember, there were a few executive orders that came out in January and early February having to do with DEI. So these are diversity, equity, and inclusion programs that many employers have. And what those executive orders signaled is that the administration had some concerns at the way that some DEI programs were being constructed and implemented ran afoul of Title VII of the Civil Rights Act. So it's an interesting situation to be in because we have these programs that are kind of designed to create a diverse, equitable, and inclusive workforce. And a lot of the goals of DEI programs are trying to kind of remedy and remove barriers for applicants and people that maybe get promotions that haven't been able to achieve those promotions or get those positions in the past. So what the current chair of the EEOC has done, one thing that they've done is sent out letters to 20 large law firms. So this came out on the 17th of March, asking information about their DEI-related employment practices. So in particular, these letter lists, it says that employers cannot limit or segregate or classify employees based on race, sex, or other protected characteristics, or deprive them of any employment opportunities, including in any voluntary groups or activities which are employer-sponsored, and there is no diversity exception to those prohibitions. So what the EEOC is doing is asking for information. This is really interesting because, first of all, this is coming from the EEOC commissioner or from the chair of the EEOC commission. Well, the EEOC commission does not have a quorum right now. and really can't act as a body. And individual EEOC commissioners in the past really haven't acted on their own accord all that much. So it's a little bit of a strange letter, and we don't know quite what to make of it, because this would not count as the filing of any complaints or anything. This is just kind of asking for some whistleblowers out there to blow the whistle on some law firms. So that's percolating around, and that happened on the 17th of March. And then just 2 days later, the EEOC and the Department of Justice put out a technical assistance document, actually two different documents, that were trying to educate the public about what is unlawful discrimination in the guise of a DEI program. And what this document says is basically unlawful DEI programs are the same thing as any other unlawful employment program. But it's given some examples of things that might be in your DEI program that could be discriminatory. So they list 4 things in here are what DEI-related discrimination could look like. So one is disparate treatment. So that's when an employer is taking an employment action motivated in whole or in part by the race, sex, or other protected characteristic. So this means anything that changes the terms, conditions, or privileges of employment having to do with hiring, firing, promotion, demotion, compensation, benefits, exclusion from a training opportunity, exclusion from a mentoring or sponsorship program, exclusion from fellowships, selection for interviews, all that sorts of things. So you can see kind of where they're going here. And this letter to the law firms is really interesting here. I think maybe if you've been in the law, you've experienced, fellowships that are open to particular groups. This says that is not okay. And then other things here are Title VII prohibits employers from limiting, segregating, or classifying employees based on race, sex, or other protected characteristics. So if you offer affinity groups, you're going to want to make sure that those affinity groups are available to everyone. If you separate your employees into groups based on race, sex, or other characteristics for any reason, that might not be okay. Even to attend trainings. We were just noodling over this before we started, and we think it's probably okay that if you have Spanish speakers, you have them in their own training if you have to train them in Spanish. But anything other than that is probably not okay. You're probably going to need to keep your workforce kind of all mixed together during trainings. Also listed here has to do with harassment. So Title VII prohibits harassment on the basis of protected characteristics. So what's listed here is saying that DEI training could give rise to a colorable hostile work environment claim. I want to ask my fellow panelists if they know what that means. Do you have any idea on how DEI training could create a hostile work environment? Because I sure don't.
Well, I'm just going to go ahead and say it. I look at SHRM, and SHRM had an article that came out today. So this is not my own personal genius, but today SHRM had an article talking about that very thing. And it gave some examples of what could happen in a training that could possibly give rise to some type of claim. And it talked about things like shaming people in certain groups in front of everyone, suggesting somehow they were responsible, or otherwise turning a training, which it's hard for me to fathom, like what kind of trainers doing their job if they're doing that anyway, but that turns something into an embarrassing experience where the finger's being pointed at you and, your genetic lineage or whatever for the state of the world or for types of claims or lawsuits that have come in. So a little plug for SHRM. I'm guessing a lot of you already subscribe to it, but they do kick out a lot of great info. And I thought that today is April 7th. I thought that the one that came out on April 7th regarding this had a lot of interesting practical pointers on this issue.
Well, that's interesting. Well, I can certainly see how a trainer not having control of the training environment might lead to that. If you had workers that are kind of going after each other about particular things, you want a well-trained trainer that can kind of keep things under control.
Yeah, the only thing I was going to add is it'll be interesting to see if those kinds of claims get brought and how they evolve, because typically speaking, to show harassment, there has to be not just someone who says, I am subjectively offended by, whatever the allegedly harassing conduct is, but there has to be this level of severe pervasiveness that shows, kind of an objective problem. And, if it's one training on one occasion, will that really be enough to actually show a hostile work environment? I would say that would be probably a hard sell for harassment claims generally, but we'll see. Maybe if someone says they've received, regular training, or they were asked to do extra training for some reason, they might be able to make out some kind of claim. So I think that will be informative, I think, to see how those kinds of claims do get treated and what factual circumstances might be enough to actually show a hostile work environment.
Thanks, Jennifer. And then the last thing on the list was retaliation, right? So the example given here relates back to the last example, and it says that an employer might be engaging in illegal retaliation if it retaliates because an individual is engaged in some protected activity, such as objecting or opposing employment discrimination related to DEI, or another example was opposing a DEI training, if the employee provides a fact-specific basis for his or her belief that the training violates Title VII. So there you go. Unpack that, right? So if we have an example of a training that is violative of Title VII, and an employee says, hey, I don't want to take part in that training, or I think that training was bad, I think that was illegal, I don't want anything to do with it, after the fact, and then the employer kind of imposes in consequences on that individual for making that complaint, that would be illegal retaliation under Title VII. So those are all things to be thinking about. The good news is they're things that you should be thinking about already in terms of Title VII broadly. Is just an opportunity to look at your DEI programs, if you have them, or if you have other programs that maybe aren't called that but operate the same way, and make sure that they are not providing any advantages to anyone based on any protective characteristics, and that everyone in your workplace and every applicant has the same opportunity to achieve employment.
I'm just going to throw in here. We had Ben Ehrwicker, the director of the Idaho Human Rights Commission, here on a prior podcast several weeks ago. If you haven't listened to that, that is a great one to listen to. And we did ask him about this. We asked him about the new guidance from the EEOC as it relates to possibly creating this cause of action related to DEI training. And I don't want to put words in Ben's mouth, but my takeaway from that is you should still do training, right? Like, be careful, pay attention. Some of those things that might give rise to a cause of action, those aren't the way that you're going to train anyway. And I would say the advantages to training are always going to far outweigh the advantage that there might be this potential new cause of action. So keep that in mind. Okay, I'm going to send it over to Jennifer, who's going to talk about the EEOC communications we've recently seen on LGBTQ discrimination.
Yeah, and I'm going to start by taking a little bit of a step back, Doug mentioned earlier how the EEOC doesn't have a quorum right now. And I do think that is especially notable in the context of what we've been seeing starting to develop in the area of LGBTQ plus protections. So just a quick little primer. There's typically 5 commissioners who are on the Board of Commissioners for the EEOC. Quorum is 3 commissioners, and by and large, a lot of the policies, protocols, and more significant decisions that the EEOC makes must be done by a quorum, so 3 commissioners. Right now, there are only 2 commissioners. And so that when we say they don't have a quorum, that is what we're talking about. There's only 2 commissioners right now, which really just, it limits what the EEOC can do right now. For example, there's not enough, a quorum would be required to rescind or change guidance. That's one example of something that requires a quorum. And that is particularly notable in the context of the LGBTQ plus protections, because last year, the EEOC issued updated anti-harassment guidance. And that guidance stated that, among other things, there were protections for employees based on gender identity. So, for example, that it was possible that restricting someone's ability to use the bathroom that aligned with their gender identity could be harassing conduct. Or, for example, that if one employee was, routinely misgendering someone and using pronouns or a name that didn't align with their gender identity could be harassment. That guidance is still in place, and without a quorum, there's not a mechanism right now to change that. Now, that being said, there have been some other smaller changes that we have been seeing that certainly are suggesting a change in the winds, if we'll say. For example, I think about a month or so ago, the EEOC made some changes to its website, had pulled down, sort of some information, had changed its intake forms to remove the MX prefix for people to select, which was the non-binary prefix, instead of Ms. or Mrs. or Mr. According to the current acting chair of the EEOC, those changes were done in order to comply with the executive order that got issued by the administration back in January. We've talked a little bit about that order on this podcast before. It's the one called Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. And one of the upshots of that order is stating that there are 2 biologically distinct genders, and basically instructing agencies within the government to make changes to comply with that order. So, with all of that being said, we've talked about there are some limitations on what the EEOC currently can do to comply with that order, but we are also seeing, I think, some relatively new additional indications that the EEOC is starting to pull back from its enforcement of protections of employees in the LGBTQ plus community, in particular in the area of gender identity. And I think 2 of the more recent developments that we haven't talked about on this podcast before, recently, I think at the it's already April, so in February, it feels like it wasn't that long ago, but it was actually a little while ago. The acting chair directed that if there are charges brought before the EEOC that potentially are in conflict with the administration's executive orders, such as the order that I was just talking about, those charges are going to be directed to the headquarters of the EEOC and subject to an additional layer of review. It's not clear yet exactly what that means or what happens after that extra layer of scrutiny. Whether or not the EEOC would just summarily deny charges that it sees as inconsistent with the executive orders or something else. So time will tell, but the message coming out right now, at least, is that there is going to be some heightened scrutiny of charges like that, which very well could include charges of harassment or discrimination based on gender identity. And the other thing we've seen happening recently that kind of is consistent with that is the EEOC seeking to dismiss lawsuits that had been pending to enforce Title VII with respect to allegations of discrimination based on gender identity. So many of you already know this, but sometimes the EEOC will actually take up prosecuting a charge that has been brought before it. And so the EEOC will be the named plaintiff in litigation pursuing enforcement of the law. And in a handful, I think maybe even up to 7 cases recently, the EEOC had moved to dismiss, it was the plaintiff and had moved to dismiss the claims that it was bringing, meaning the EEOC walked into court and said, we no longer wish to pursue this claim that of discrimination based on gender identity. We'll see what happens in those cases. In some instances, some individuals have sought to intervene to keep the cases alive and going. But all to say, even though the law itself has not changed, we've talked about Bostock here before, which said that prohibitions in Title VII against discrimination or harassment based on sex includes a prohibition of those things based on gender identity and sexual orientation. Last year's guidance, all those things still remain in place currently, but there have been signs of a shift in the trends that I think, employers want to be aware of. Right now, I would say it's primarily impacting, employees and individuals who would seek to bring claims. Employers, from their perspective, the law still is the law, and, compliance right now, I would say, again, Bostock's still out there. You're going to want to comply with that, but be aware, keep abreast of what's going on, because, there could be some lawsuits, or if the commissioners get a quorum and start making more substantial changes, there really could be a more seismic shift, I guess, in what enforcement of Title VII looks like at the EEOC, what compliance looks like for employers going forward.
Yep. Thanks, Jennifer. Again, go back and listen to that podcast with Ben Earwicker if you haven't had a chance to. I feel like we were so lucky to get him on our podcast because we were able to ask him some of these difficult questions about these changing EEOC philosophies. Again, he's with the Idaho Human Rights Commission, not the EEOC. And I think that after we spoke with Ben, we felt a lot better about the state of the law, because some of these things are really radical departures. They create a whole lot of risk and uncertainty for employers. What are you supposed to do with EEOC guidance that contradicts existing United States Supreme Court case law? I feel like when we talked to Ben, his answer was very calm and reasoned. And he said that on a local level, so if you're here in Idaho, our Idaho Human Rights Commission is still prosecuting LGBTQ plus claims and will do so in a fair and even-handed way. So that's good news for us. So again, I think a lot of these things just come down to we're waiting to see what's going to happen. We don't know. Things are in flux. there are a lot of unknowns and uncertainties, and all we can do is stay on top of it, track it, watch the communications, the guidance, the case law, and see what happens. So I'm just going to wrap things up by talking a little bit about some of the other EEOC cases that we've seen come across our email in the last month or so. Pregnant Workers Fairness Act remains an enforcement priority for the EEOC. I saw a case from last week where the EEOC was had settled a pregnancy discrimination case involving a pregnant woman. She'd taken maternity leave, and when she went to return to work, they refused to allow her to return. They said there was no work, and then they gave the job to someone else. And that resulted in some cash out of pocket for that employer. So stay on top of the Pregnant Workers Fairness Act obligations. That's been a priority for the last year. It remains a priority. I hope employers are watching that because it's a different framework than the ADA, and it does require knowing some new rules and having some more training than what you would have otherwise had. So I'm seeing cases on that, and then some of our standard, what I would think of as maybe old school, because now we've had the Americans with Disabilities Act amendments in place for like 15 years, I guess. So I'm still seeing some cases that kind of go to the heart of the ADA amendments. I saw one that involved an employee who had been diagnosed with cancer. His employer didn't let him return. There was a disability discrimination claim on that one. There was another one that involved a worker who had type 1 diabetes. They had asked for accommodations to have breaks so that they could have snacks to make sure their blood sugar remained stable, and the employer had refused. That was another disability discrimination claim. So Pregnant Workers Fairness Act, learn it, know it. ADA, make sure you know how to spot issues under the ADA and to have your policies and protocols in place with that one. So that's all of our time today. Thanks for joining us on Ground Rules. And despite everything you heard Doug say, you should still get training. So we've got our Law for Leaders training, virtual, in person. I would still advise better to get trained than to take your chance that there's some new cause of action on there if you don't have perfect training. Or better yet, hire people who train all the time so we make sure it's done right. Check out the training, check out our book, Law for Leaders, the roadmap every leader needs to follow to avoid workplace claims and lawsuits. We cover a lot of these issues in there. There's a Pregnant Workers Fairness Act chapter, numerous chapters on the ADA, and lots of other good stuff. So check that out too. Otherwise, that's it. Thanks for joining us on Ground Rules.
Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.